Okay, we're live. Hello, good evening, and welcome back to the Law Intense YouTube channel. Today is going to be a special video. Firstly, because it is my first video of this particular year on the topic of legal reasoning, on the subject of legal reasoning. And secondly, because today would be a foundational class which would help you understand the subject a little bit better, which would help you understand how to approach legal reasoning in the CLAT exam and how to look at principles, how to look at facts, how to decode these principles, how to apply these principles to the facts, what are some important rules you need to remember while solving questions of legal reasoning, and how to make the most out of this scoring section in the CLAT exam. So let's dive right into it without any further delay and let's begin today's class on understanding legal principles and its applications. I'll quickly share my presentation with you all. All right, here we go. So let's start with the agenda of today's class. What are we going to do today? Primarily four things. First, we would be decoding the section. By decoding, I mean we'll be understanding what exactly to expect from the legal reasoning section in the CLAT exam. Then we'll be looking at some important points which are to be kept in mind while solving this particular session. Then, of course, the most important thing, how to approach this particular section. And then we'll be looking at some actual examples, actual legal principles, and some questions based on that. So this is going to be a very value-packed class. Make sure you stay till the end and make the most out of it. And let's begin now. Anurit is here, Priyanshi is here. Good evening, guys. Welcome to the class. That is the agenda for the day, which I have just set. And we are beginning. Okay. Let's start by talking about the legal reasoning section, understanding it a little better. Why does it even exist in the first place in the CLAT exam? Because one might wonder, you are not lawyers yet, you are not law students yet as well. Why are they testing you on questions of law? Now, there's a problem with that. They are not exactly testing you with questions of law or asking you questions of law. They are asking you application of these legal principles or legal concepts. What they're trying to test here is whether you can grasp what is being mentioned in the law and apply it to a factual situation. Basically, it tests your understanding of legal concepts and the ability to apply them logically. Logically being the keyword, because all of our legal framework, our legal system is driven by logic. All the laws are framed on logic. None of the laws are illogical in nature, just based on whims and fancies. Everything has a rationale behind them, which has either been shaped up because of history, because of culture, because of religion, because of societal factors, and number of things. But there is a logic behind every law, and they want to understand whether you can get that logic or not, and that would help them filter out probable good lawyers and probable good law students. How are the questions framed? The questions are in a simple passage which contains a legal principle or multiple legal principles. And then they have multiple questions, usually 4 to 6 questions based on that particular passage to test your reasoning and not your prior legal knowledge. This is also mentioned on the website that prior legal knowledge would not be tested. But is that entirely true? We'll come to that very soon. But on the face of it, they have mentioned that they are not going to test your prior legal knowledge. They are just going to test your reasoning ability. So how many questions do you get? You usually get 32 questions out of the 120 questions on the topic of legal reasoning, on the subject of legal reasoning, which makes it a very, I would say, dominant section in the CLAT exam, a very important section in the CLAT exam, and a section you cannot really not be good at. And most students usually find themselves to be comfortable with this particular section after a particular amount of concept building and practice. And that is our aim as well. What are they going to test? What are the skills they are assessing? We already discussed. They are testing whether you can comprehend the principles, whether you can apply the law to the factual scenario or facts, and whether you have the logical reasoning it requires to derive the conclusions. All of what we are doing is deriving conclusions. Okay, what does this law mean? What can we conclude? What can we understand from a law? What can we understand which can help us solve this legal problem or factual scenario? So that is basically the whole legal reasoning section and its purpose, its format, and why is it there in the first place, right? That being said, let's move on to the next part, which is some important information. Now, the first point is very important and very crucial to understand. No prior legal knowledge required. Now, this has two nuances. The first nuance is principles are provided in the question, and that's correct. And you have to stick to that principle while solving the questions. We'll also talk about that when we talk about how to solve or how to approach the section. But the principles are 99% of the times given in the question. I'm saying 99% because there have been cases when direct questions have been asked. But yes, 99% of the times you would get the law on which the question is framed in the question, and you would have to interpret that particular law. Now, the second nuance is, does it matter if you have legal knowledge, prior legal knowledge, or not? Would it make any difference in your approach or in your confidence or in your conceptual understanding? The answer to that is both again, yes and no. It depends. It depends on what exactly is your prior legal knowledge base. If you are thinking that I would study every law in the country, I would study company law, space law, animal law, environment law, marriage law, administrative law, merger and acquisition law, IPR law, would that be helpful? Would that help you in the CLAT exam? The answer is most likely not, because that's not required. First of all, that would be a waste of time. Thirdly, you don't know if a question would be asked on that. And fourthly, the past year papers suggest that these type of topics are very rarely asked in the exam. Now, why did I say yes as well? Because there are four topics on which questions have very often been asked, most commonly been asked. You can also see them in the third point, the focus areas: the law of contracts, the law of torts, criminal law, and constitutional law. These are the four pillars or four topics or four areas of law from which questions are framed almost every year without any exception as such. And that being said, it is definitely beneficial if we have a basic understanding of these four concepts. Now, that would account as prior legal knowledge if you look at it very strictly, but that is required. I would say it is always beneficial to have that prior knowledge of contract, torts, criminal law, and constitutional law. The basic principles of what are the essentials of a contract, what are the type of torts, what are the exceptions, what are the basic criminal law provisions, what are the basics of constitutional law and the Indian Constitution, what are the basic articles, what are fundamental rights. All these things are very frequently asked as questions. So it always helps to have a good understanding of them through your prior legal knowledge. दैट बीइंग सेड, ऐसा नहीं है कि अगर आपके पास ये नहीं होगी तो आप क्वेश्चन बना ही नहीं पाओगे. हो सकता है आप बना लो, बट इफ यू हैव दैट प्रायर लीगल नॉलेज, योर एक्यूरेसी वुड डेफिनेटली शूट अप. Okay. Now, here comes a disclaimer and a caveat, which is you need to keep a neutral mindset. That means you need to avoid your personal opinions or assumptions related to either your prior legal knowledge or what is given in the fact. Stick strictly to the principle given. Now, what do I mean by that? By that, I mean when we would possibly study criminal law, we would study about offenses like battery, assault, murder, culpable homicide, amounting to murder, culpable homicide, not amounting to murder. Now, any reasonable or prudent man would say that murder is illegal, murder is wrong, murder is morally incorrect. But what if your principle, let's say, says that murder of old people greater than 50 years of age is not a crime? That is your legal principle in the actual CLAT exam question. And the fact scenario is something like that: person A murders person B who was 55 years of age. And you have to decide his liability, the liability of A, whether A would be charged of murder or not. What would be your answer? Will A be charged of murder or he would not be charged of murder? Yes or no? He would be liable for murder, yes or no? Please tell me in the chat box. Anurit, Priyanshi, Udit. Udit is saying, put my heart and soul into CLAT, but did not get a satisfactory rank. Reappearing for the exam will do amazing that time. Love that optimism, yeah. I really, really hope you do as good as you aspire to be, and even better than what you aspire to be in the upcoming 2026 exam. Priyanshi says the answer is going to be no, that he would not be liable for murder. Ravi is saying, यार रवि मैंने आपको बताया था पिछली क्लास में बताया था Christ Law School is decent as compared to SLS Hyderabad. I would keep Christ above SLS Hyderabad. ठीक है चलो. All right. So yes, the answer is gonna be no because the principal says so, and you have to stick to the principle very strictly. If the principal says it's not a murder, it's not a murder. ठीक है, even if your personal opinion or assumption says that अरे ऐसे कैसे तो हो सकता है, ठीक है. Now, one important point to remember is that you need to interpret terms like must, may, shall, liable, not liable very carefully when they're mentioned in the principles or in the fact scenario. We'll look at it through examples and questions later on in the subsequent classes. But remember that all of these terms mean different things. Must is different from may is different from shall, and so on, right? So remember that. And lastly, and most importantly, you have to manage your time because anyone can solve these 5, 6 odd questions or 32 questions if they are giving if they are given unlimited amount of time. But you have to solve a passage, which means reading the passage and solving the questions within 8 to 10 minutes, ideally less than 6 minutes, but this is the maximum you can spend on a particular passage, right? If this is clear, let's move on to the next part, which is approaching the section. How do we approach the section in the questions? The first and foremost thing is quite obvious. You would be reading the principle first. You'd be understanding what is the scope of the principle, what are the things it is talking about, what are the key elements, and then if there are any exceptions or conditions mentioned. जैसे कई बार होता है principle में कि let's say let's talk about defamation. Okay, defamation, let's say it's called a crime, but उसके exception में दिया गया है कि truth is an exception to defamation. So that is something which you have to keep in mind while solving the factual scenario कि अगर कोई इंसान सच बोल रहा है और उस पर defamation का charge लगा है तो he would not be liable for defamation even though आपको fact से लग रहा हो, but अगर facts में लिखा है that he spoke truth, so that would be an exception. So be careful of conditions and exceptions in the principle as well, along with the scope and key elements. Then, of course, the next point is analyzing the facts carefully, quite obvious, spotting relevant details and connecting them to the principle. You would be given a fact scenario जहाँ पे कुछ ना कुछ चल रहा होगा and आपको देखना है आपका principle वहाँ पे किस तरीके से apply होता है, किस तरीके से connect होता है. And of course, disregarding irrelevant information. Your facts sometimes might have information which is not at all useful to answer the question, which is just a filler information, or sometimes even information to remove you from the right track or to deviate you from the right track. So you have to identify that what are the relevant details and disregard the irrelevant ones. Then, of course, applying the principle to the facts, matching the facts to the conditions stated in the principle, eliminating wrong options, and using your brains, using your common sense, logical reasoning, critical thinking to narrow down your choices. There would be 4 choices, A, B, C, D. Out of that, in most of the cases, you would be able to eliminate, let's say, 2 choices, A and D. And then you would obviously focus your energy on 2 options, option B and option C. And then you would obviously pick the option which is most aligned with the principle, which is most closely following the principle. This is a very important point which you have to keep in mind while solving questions of legal reasoning, because this is where a lot of students go wrong. They trust their intuition, gut feeling, whatever you might call it, but do not check which option is aligning more with the principle. The one which aligns most with the principle is 99% of the times the correct answer. Now that we have seen how to approach the section, some important information, and we have understood the purpose and the format of the section, it is time to look at an example. This is a very short example. After that, we'll be solving actual questions. So you have a principle, you have facts, and you have a question. You have to tell me your answer. Simple one-word answer, liable or not liable. You guys have 20 seconds. Priyanshi is saying change the timing of newspaper analysis to a little late, becoming tough with school. We can think about it. We will Definitely think about it. I'll let you know if that is possible. Because there are other classes aligned as well. 6 p.m. say there is Salik Sir ki class, 8 p.m. say you have these subject wali classes. So it's gonna be a little tough, but I'll see what I can do. Okay, answers liable or not liable? Shreya says liable. What about others? Priyanshi also says liable. And that is the correct answer. Yes, he would be liable because we can clearly see that he did not act with reasonable care and harm was caused because of lack of care. Because driving very fast through a crowded market and hitting a pedestrian, you can clearly see that is an act of negligence and therefore he would be liable for negligence. So, this is a very simple example of how you apply the principle to the fact and answer the question. Now, we would be solving an actual question where you would have a complete paragraph which has legal principles, and then you would be able to you would be required to solve actual factual questions based on this. So you have 45 seconds to read the paragraph which contains your legal principles, and then we'll solve 5 or 6 questions based on this. Give me a done in the chat box when you are done reading. Okay, everyone is done. Okay, let's start solving some questions. This is the first question on your screen on the right hand side. Let's solve it. Simple one. Priyanshi has given her answer. Udit has given his answer. Okay, waiting for Shreya. Okay, Anurit is back and has also given her answer. And yes, that is the correct answer. Option number B. The court should evaluate whether the statement was true and was made for public good, because the last line of your principle says that it's only a valid defense if it is true. That is, truth is a valid defense, and only if the statement was made for public good. So दोनों चीजें देखनी पड़ेंगी कि public good भी होना चाहिए, true भी होना चाहिए, and that is what the court would evaluate. The rest of the options are not relevant or incomplete or off track. So yes, good job. Let's do the second one. Question number 2. Also, guys, do mention the question number when you are answering. So, when you are answering question 1, answer it as 1.b. When you are answering question 2, answer it as 2.a or 2.b so that I know. Okay, Priyanshi, Shreya, Udit have answered. Let's check. A journalist writes an article accusing a business tycoon of unethical practices without presenting any supporting evidence. The business tycoon sues for defamation, arguing that the article was false and damaging. How might the principles from the case guide the court's decision? Should protect the journalist's right to free speech regardless of the accuracy of the statement? No. You have to check for defamation. Should consider whether the article was written with malice or for public good. Can be there. Should dismiss the case as business tycoon is a public figure and must tolerate criticism. No. Should automatically rule in the favor of journalist as freedom of press is paramount. No. Nothing is paramount. As you can see, all the other options are irrelevant or extreme. Option number B becomes the most suitable answer. Let's do question number 3. Waiting for answers, people. Priyanshi says B, Udit says B, Shreya says B. So a lot of B's as answers to all the questions. But yes, that is the correct answer. During a television debate, a participant accuses another of being involved in criminal activities without any evidence. Accused sues for defamation. Defendant argues that statement was part of heated debate, should be protected under free speech. Court should dismiss the defamation claim as statement was made during no, that is not enough. Should assess the accusation if it was supported by facts or whether it was with an intention to harm. That is the basic principle of defamation. Court should rule in favor of defendant as debates allow free expression. No, there are restrictions. Should automatically side with plaintiff as unsubstantiated accusations are inherently defamatory. No, they are not. So B is the correct answer. Well done. Let's do question number 4. Okay, most of you have answered B. The question says social media influencers posted a tweet alleging a popular actor is involved in illegal activities. Actor files for defamation, claiming it was false and damaging. Influencer defends the tweet as personal opinion protected by free speech. How might the court, referencing the Swami ruling, evaluate this defense? Okay. So उन्होंने कहा था it can be restricted to protect the rights and reputation of others, the right to free speech. The court should dismiss the defamation suit as social media posts are considered informal opinions. No. Should determine if the tweet was presented as a fact or opinion, whether it was made in public interest. Uh, okay. Should automatically protect the tweet under free speech? No, automatic protection नहीं होता. Should require actor to prove the falsity of the tweet? No, not really. B is also not a very good option, to be very honest. First of all, it's gonna be defamation or not is not dependent on whether it's a fact or an opinion. If it is a statement which is false and harms the reputation, that is enough, no matter if it was a fact or an opinion. But yes, if it was a true fact, then that might be a defense. So अगर यहाँ पे fact का मतलब इनका truth है, तो वो चीज हो सकती है, एंड वेदर इट वाज मेड फॉर पब्लिक इंटरेस्ट. सो दे हैव बेसिकली टॉक्ड अबाउट बोथ ऑफ द एक्सेप्शंस कि अगर वो फैक्ट है यानी कि ट्रू है तो डिफेंस मिल जाएगा, अगर इट्स मेड फॉर पब्लिक गुड. सो दैट मेक्स बी द बेस्ट ऑप्शन हियर. लेट्स मूव टू क्वेश्चन नंबर 5, which I believe is the last question of the day. Let's do this. The question make loves B, I think. Yeah, you're probably right. All four of these questions are siblings. See, these are foundational classes which are primarily focused at building your concept, at making you think. So don't expect tough questions right in the first month of preparation. We level up slowly. These are to make them more inclusive for everyone. I won't be surprised if the answer to this one is B as well, because looking at the Udit is saying, isn't a fact inherently the truth? Interesting. Well, it is a truth unless proven otherwise. So, yeah, you could say that. A fact is true till it is disproved. ये वाला भी है क्या? बाप रे, that's crazy. That's outright crazy. Okay. Need to have a word with the question maker. Anyway, question 5 says a newspaper publishes an investigative report alleging that a government official misused public funds based on information from anonymous sources. Official sues for defamation, arguing that the report is false and has damaged reputation. Newspaper defends as it as a matter of public interest. How should the court proceed? Court should automatically dismiss the defamation claim. Nahi. Should require the newspaper to prove the accuracy of the report and its intent. हो सकता है. Court should protect the newspaper's right to report on matter of public interest regardless of the accuracy. No. Should side with the government official as the report was based on. No. So once again, yet again, B is the correct answer. It's the most appropriate one. And I hope this short exercise, although this was very easy and all the options were also sort of similar, all the questions were also on the similar lines. But I hope this gave you a very basic fundamental idea as to what to expect from questions. Obviously, इतने easy नहीं आएंगे सारे questions CLAT exam में, and obviously सबका answer भी नहीं होगा. But this is the first class where we actually begin as to understanding how to approach this particular section. Moving ahead, we would be looking at a diversity of questions, probably a change in the difficulty level as well to a certain extent, definitely different options as answers. And then we'll slowly move on towards concept building, where we'll take up contract act, criminal law, constitutional law, tort law, and we'll break down smaller concepts, smaller topics in each of those fundamental areas of law. So stay tuned to the channel, bring your friends as well. Do subscribe if you haven't yet, and do drop a like on this video. and I'll see you in the next one. Now we'll be meeting each other every Friday for this legal class, so make sure you are regular to that, and we'll be slowly leveling up. But that's all for today's class. Thank you so much for participating, guys. Priyachi is saying, and is that with classes enough to practice? What do you mean by classes? The CL classes? So, books provided by CL should be completed in how much time? Ideally, 2 to 3 months should be more than enough. I believe they are not very lengthy. They are comprehensive and should be covered in 3 months ideally. Okay. Okay, Udit is saying I completed modules in a month and large book of PYQs in 2 months. Yeah, it depends on your pace and how much time you have, honestly. If you are a school going student, then it might take month or two. If you have more time, then probably a month. So yeah, go as per your pace. And yeah, I'll see you in the next one. Thank you so much. Bye bye, guys. Signing off.